Good morning, everyone. My name is Greg Van Buiten. I'm an attorney practicing in Vermont and New Hampshire. I live in Milton, Vermont, and I've been doing education and special education law for over 30 years. I'd like to thank Katie Berto and Martha Frank for helping me set up this webinar. And it should be interesting, and let me tell you a little bit about who I am, just so you know, because I know you can't see me. And this webinar is about communication and conflict resolution. I'll explain more about that in a minute. So on this slide you can see I'm an attorney who concentrates in education law. That's pretty much all I do and all I have done for a long time. My phone number and email are on the screen there, and my office is in Milton. I practice in Vermont and New Hampshire, as you can see on this nice old map. I like to spend free time with my dog Scout, who was born in the Northeast Kingdom. At the moment, she's very spoiled, which is not my fault, as you can see. So this webinar is when I was talking with the folks here at VFN a little bit about what we might want to do. We decided to do something that's just about how do you try to resolve conflicts or issues that come up where there's disagreement even before you get to a mediation process, a formal mediation or a due process request, or all those things that are in the regulations for conflict resolution. What are some of the things you can do even on a day-to-day basis to try to get things worked out? So that's what my focus is today, and I'm not going to be talking much about those other dispute resolution mechanisms that are in the law. So we all know that the education of students with disabilities can be all these things: very difficult, complex, stressful, expensive, but we also know it can be very rewarding when we are involved in getting the needs of a student met and when we see good things happen. But the difficult parts of the process can lead to conflict between parents and professional educators. And so we're going to talk about some of the things that can be helpful in that context. Mostly I've tried to focus on some simple common sense things to think about when a disagreement comes up. Some of these things are very elementary, I suppose, and even though they seem very simple and elementary, I think they are important and they can lead to productive results. So let's talk for a moment about which students we're addressing today. This slide is about the first group, which is the IDEA eligible students, the ones who are eligible under the Individuals with Disabilities Education Act. These are the kids who would wind up with an IEP if they are found eligible. And in Vermont we have 12 categories of disability which are listed here. For these students, the ones on IEPs, a number of conflict areas can potentially arise. Is the student eligible at all for services? How are we going to evaluate the student to make that decision? Or for students who are already eligible, when we do a reevaluation, what should that look like? Sometimes there can be disagreement about those kinds of issues. And then, very importantly, if a student is eligible, what services should be provided? And specifically, what services? How many hours of services? How many times per week? With what kind of service provider? Is it one-on-one or is it small group? All those sorts of things. Then we have disciplinary issues. The disciplinary issues are in some ways getting more complex, and they can relate to things related to suspension or bullying or harassment. and decisions about whether certain behaviors are related to a discipline or whether they're unrelated. Issues around summer services, issues around what type of school a student needs to attend or the location of the school, and then kind of the ultimate question, are the student's needs being met, and is the student making progress? Any of these things can lead to areas of either disagreement. It might just be honest disagreement. It might be a philosophical difference. It might be a difference in how data is being read or interpreted. But any of these things can lead to a place where some dispute resolution needs to take place. The second group of students that we're talking about today are the 504 students, and I'm only putting in this slide to make the point that even if a student is not eligible for an IEP under the IDEA, in many ways that is not much of a barrier anymore, because any student who has a disability is going to be eligible for services under Section 504 if that disability substantially limits a major life activity. So you can see in this slide the definition of a disability is extremely broad. It's the bulk of this slide. And there are a lot of things that are included in disability under 504 which are not listed because no one has tried to make a complete exhaustive list. If they did, it would be a whole book basically. But for example, things that are not listed but that are disabilities under Section 504 include asthma, Lyme disease, allergies, all sorts of things, anxiety issues, all sorts of things that you might not necessarily think of as a disability, but keep that term in your mind as very broad. And then there has to be a substantial limitation on a major life activity. In red at the bottom of this slide are major life activities defined, and you can see how broad this is. It includes walking, seeing, hearing, speaking, breathing, learning. I mean, those are very broad terms. It covers just about everything. And when you try to decide whether a disability substantially limits, that term substantially limits just means that it has to affect the student more than it affects the average person. So that is also not a very high bar to cross over. By the way, if you have questions as we're going along, as Katie mentioned, you can text them in and we might answer them at the end unless they're clarifying questions as we go. Some of the issues of disagreement or conflict that may arise under Section 504 are very similar to the ones we discussed a moment ago for the IDEA. You might have issues around whether the student is eligible, and as I said just now, it is not difficult to be found eligible under 504, so that's a very broad group. And then how do we provide an education for the student under Section 504? And the question there, since Section 504 is a non-discrimination statute, meaning we want to make sure that any student with a disability under Section 504 has an education that's where the needs are met as adequately as they are met for students without disabilities, so that there's a level playing field. If we don't have a level playing field, then it's discriminatory. So the question there is, how do we do that? And for either student, the IDEA student or the 504 student, the question is really, how do we provide an appropriate education that meets the needs of the student? And with 504, you're also asking, as you see at the bottom of this slide, what services should be included in the 504 plan. And then you have similar issues to what you have under an IEP. What are those services? How frequent how frequently are they provided, what's the intensity of the services, who are the providers, and so on. So some of the things that I'm talking about today are just things that I do in my practice. As a lawyer, I'm representing parents, and usually parents are coming to me and they have a particular problem, like my child isn't doing well, my child is not wanting to go to school, I don't feel like my child is making progress, I don't feel that the recommendations for my child are being followed, or whatever the issue is. And a starting point for me is always the records. I always want to see the records, and the reason is I want to get a feeling for the student, and I want to get a feeling for the history. What has happened in the past to bring us to this point where we are today, and what does that information tell us about where we're going? And usually the records issue is problematic for most parents because most parents do not have the records together. And after I talk with a parent, they will try to put them together. So whether or not a parent is in touch with an attorney, or even if a parent never does get in touch with an attorney, this records thing is very useful to talk about. If you create a system, it's going to simplify things tremendously and help in a number of ways. And for me, there's only one good way to do this. You create 3-ring binders with all of the records chronologically. You include in the records the medical documentation you have if it relates to the disability or functioning in school, all the educational records, evaluations done by school staff, evaluations that you've had done privately, IEP documents, and everything. You put them in the binder chronologically with the earliest first so that the binder reads like a story. When you read it or when someone else reads it, you read a story and you get this student's story in your head. And that's a very important beginning step. You can insert a tab for each school year so that the school years are easy to locate. And then as you go through time, during the entire time that your child is in school, you'll just update the document by whenever you receive a document from the school or from an outside evaluator or a hospital or anything that's related, you just punch holes in it and you put it in the back of the binder. And maybe there's a shelf in the house where you have the binders, and when the binder's filled up, you start another binder, but your whole student history is in those binders. Someone just made a face at me through the window. So the record system, it's going to keep you from going crazy. It's going to give you a place to put everything. It allows you or anybody else to easily review the history. And as I say at the bottom of this slide, it allows for the big picture. What has happened, big picture, let's forget the little details for a minute and see how we got to this place. So when a conflict arises on any of the issues we talked about earlier, about eligibility or services or what have you, the best place to start is with a focus on the existing records. So even if whether it's a parent, somebody at VFN, a lawyer, an evaluator, a school professional, looking at the records and looking for particular issues is very helpful. For example, how long has the student been receiving services? Has it been 1 year, 6 years? Has the student never received services? And what about comparing the testing and other data over time? Do we see progress in the scores and in the data? So if a Woodcock-Johnson reading test was administered in 2nd grade, and the student is in 6th grade now, and there was another Woodcock-Johnson reading test done at the start of 6th grade. Let's compare the numbers from 2nd grade and 6th grade and see, are those numbers going up? Are those numbers going down? Are they staying the same? What's happening with those numbers? And bearing in mind that the numbers on testing like that are just one element to look at. We also want to look at what teachers have to say about the student's progress. And when we go back over the records, do we see a lot of reporting of progress, or do we see reporting about lack of progress? And when we go through the records between 2nd grade and 6th grade, or 1st grade to 8th grade, or whatever it is, do we see recurring issues? Do we see that the student is struggling with getting along with other kids in kindergarten, and then in 4th grade and in 7th grade? Is that a recurring issue? Is there a recurring issue that the student is anxious about attending school? Is there a recurring issue that the student is unable to get work completed? Is there a recurring issue that that understanding math is problematic? You will get a big picture. And when I review a binder that a parent has given me, I have the luxury of stepping back and looking at that big picture. And when you do that, you see these things. And so I might say, oh, look, I can tell that this thing that's going on in 7th grade was going on in 2nd grade. It's been going on for 5 years. So, identifying those kinds of issues is very important to do. You start to get an idea just from this step what's missing from the picture. Where are the areas where maybe there has not been enough attention given, or maybe a lot of attention has been given, but progress isn't made. If progress isn't made, then why isn't progress being made? But you can start to focus on what the issue might be. Or you might see that there's a recurring issue with math, or with attention, or with anxiety, or with peer interaction. But you might see that it's never been evaluated in a formal way. And so even though an issue keeps recurring over the years, maybe it hasn't been looked at in enough depth. When a conflict arises, I think one of the most difficult things for probably everyone, a parent, an educator, a lawyer, anybody, is to not get sidetracked. There are a ton of ways to get sidetracked and to lose focus, and there is only one focus in these situations, which is the student. The student, this slide with this girl, she's supposed to be a student. When my wife looked at this slide, she said, "Is that a teacher?" And I said, "No, that's a student." So you have to stay focused on the student in the circle. There are always tons of things outside the circle that I call static. Some annoying email, or something that happened years ago, or something that you heard about from another student in some other school, or a bunch of paperwork that doesn't really matter, or some rumors, or whatever it is. Usually when I'm talking with people, there's that central circle with the student in it, and then there's all the static. And you have to try to identify and eliminate static and just focus on the student. Once you have reviewed your records, you've organized your records and you've reviewed them, and you stay focused on the issue, which is the student, you want to identify what is your goal for the student. And that seems like a simple question, but usually when I talk with parents, it's not easy to answer. What are you trying to accomplish? A lot of parents will say, I want my child to succeed, or I want what's best for my child, but what you really want to focus and what you really need to try to identify is something much more specific than that, which is, what is it specifically that you believe your child needs that she or he is not getting? If you have a dispute, then that means probably that there is something that the child is not getting that would lead to progress or that would improve the situation. You need to try to identify exactly what that is with as much specificity as you can. Your goal, though, is not a Cadillac. The law doesn't require the school districts to provide the best possible education or a big spiffy Cadillac education. The law does require something better than an old junker in the weeds, though. The law talks about meeting the student's unique academic and functional needs and receiving an appropriate education and making meaningful progress. But it's very important in the beginning to get your head around the idea that it's not a spiffy Cadillac. You want to identify these needs, but you want to stay real about it. And if you stay real about it and focus on needs, then you're going to have a realistic discussion with school staff. You're going to have a realistic discussion with anyone who evaluates your child, and you're going to keep the whole thing real that way. When you think about, and one other point about that, there are numerous cases where the parents were advocating for the best possible services, and in the end, the judge or the court in those cases said, unfortunately, we cannot rule for the parent, or we cannot rule for the student. We cannot order these services that are being requested because the parents are simply trying to obtain a Cadillac of an education. So that's another reason to focus on the needs from the very beginning. When you think about these needs, do not focus only on academic needs, because the law clearly requires that we address academic and functional needs. So yes, the traditional academic needs about reading, writing, and math need to be addressed, but also the functional needs means everything else. All of those skills that you need to function in school or in the workplace or in post-secondary education or in independent living later on, things like conflict resolution, teamwork, work completion, healthy choices, independent decision making, all of those are just as important as academic skills, and they're all things that the law wants to see addressed. So when you're trying to determine, as you're staying focused, as you're reviewing your records, as you're identifying your goals, be sure to include the functional goals as well. How do you identify your goal? Well, you're looking at the records. We've talked about all this stuff. If those records don't help you to answer that question, then you might need new evaluation data to either prove or disprove your belief that certain changes must be made. And if you're not able to identify the specific changes, you might need additional evaluation data to describe what those specific changes might be. Let's look at the situation for a moment where you can organize your records, review the history, and you might actually be able to come up with some proposed changes to improve the programming just based on that process? If so, you can write up your proposed changes to the plan or to the services in a simple, user-friendly way, make reference to the documents that you're relying on, be as specific as you can about what you'd like to see changed, request a meeting with the school staff to discuss what you've come up with, provide that information to the school in advance, and most school professional, almost all school district professionals are professional. They're open to suggestions. They've entered the field of education to help students. They're super busy, and they may not have had the time to do what you just did. Compile all these records, go through them, compare the results over the years. They're so busy with all the kids in school that if you do this job and you bring it to their attention in a clear and user-friendly way and in a respectful way, you might get your thing resolved in that kind of a process. Most school district professionals appreciate a parent doing that kind of work. Most parents have some barriers to doing this kind of work. It might be lack of organization in terms of the records. There's lots of times there's, just records scattered all over the place, or records come in a shopping bag or whatever. A lack of focus on that central issue of the child in the circle in the center of the page. There's too much scattered focus on issues that don't really matter. Maybe a lack of clarity about exactly what it is you're looking for. Or maybe a lack of specificity. Maybe the goal is just too general, like I want my daughter to do better. But probably more than any of these are the emotional impacts that can get in the way, just simply because you love your child, and when you love someone, it's just more difficult to stay objective, like an advocate or a lawyer can stay objective, and it's the reason why doctors can't operate on their own children. The emotional impacts have to be recognized. When you follow these steps, it helps to create a framework for you, and it helps to make the emotional issues less overwhelming. And even if there still will be emotional issues, but the process of focusing on specific issues based on records and the steps we're talking about will help. What if you can't identify your goal? You've looked at all the records and you've done all this stuff, but you just can't figure out where you want to go with it. Then you're going to need additional information. That additional information is often going to come from a source outside of the school district. If you and the school staff are in disagreement, it's often helpful to get another opinion and another perspective and another set of recommendations from an outside source. And that usually means someone who does evaluations with students, or someone who does therapy with students, or someone who's an expert in whatever the issue is for your child. This is often the case because if you're in a place of disagreement with school staff, then you know by definition that the existing records that are on the table have not been sufficient to resolve the issues. There's still a conflict. Usually the school district professionals have conducted their own evaluations, and they've gathered their own or created their own records over time about the student and about progress, and yet there is still a conflict, because that's the setting we're talking about, where there's a conflict. So then it is common that outside independent information can be the thing that breaks the ice or creates a new perspective or gets a new conversation going. An independent evaluation is just what it sounds like. It's done by someone who's independent. So the person is not an employee of the parent. The person is not an employee of the school district. And that person does an evaluation and makes independent recommendations. Sometimes the parent pays for that evaluation to be done. It's very clean and simple when it's done that way. Sometimes there is insurance coverage for an evaluation like that. Sometimes parents ask the school district to pay for evaluations like that, and that can be okay, but and there are lots of situations where that is a good thing. Just think about whether, if you're going to get an independent evaluation, whether you want to seek financial assistance from the school for it, or whether you want to go and get it independently, and you can weigh the pros and cons of those two approaches. When you go to get an independent evaluation, you need to be an active player in that process. And being an active player in that process is another one of the steps that in conjunction with everything we're talking about today, that can be very important. So you already have your chronological binder of records. So if you're going to get an independent evaluation, you're going to be able to provide the evaluator with a very clear, concise set of documents that gives the evaluator a clear picture of what's happened in the past, how we arrived at this present situation, what things have been tried or not tried in the past, and what areas it might make sense to evaluate in. You don't need to swamp an evaluator with emails and all kinds of kind of tangential issues or static. Just the basic things. Then you want to give some thought to the questions that you're hoping to have answered. And you can write these questions to an evaluator so that you can help to focus what the evaluator is looking at. And since you're one of the best sources to talk about what areas we want to look at, it's important that you do that. So you might write out questions. Does my daughter qualify for services as a student with a learning disability? Or what are my daughter's current skill levels in the area of reading fluency? Or what services does my daughter need in reading fluency? Like how many times a week? And is it one-on-one, and how long do the sessions last? What will she need to make progress specifically? Not just, well, she's going to need some services in reading fluency. Ultimately, the team will decide what services go in the plan, but it's good to have recommendations from evaluators to help team members make that decision. These questions are all based on need, as we said before, and they're not Cadillac questions. You know, you're not asking, how can my daughter get the best possible reading services? Because that's not a legally relevant question. You're focused on need. You might also, in number 3 on this slide, you might also request that the evaluator conduct some apples-to-apples testing. And that means if you can see that testing's been done in the past, you know that because you've been through your chronological binder. You know that there was certain testing done maybe in reading fluency back a few years ago. You might want to do that same test again so you have apples-to-apples over time, and you can see whether progress is being made or not made. This chart here with evaluation instruments is just a couple little examples where you can help the evaluator review the file and look for past test instruments. It's a time-consuming thing to do. You know, especially the older the student is, the more years worth of records you're going to have, and the more time it's going to take to go through and identify this. But you can create a chart like this if you want to. This hypothetical one is for someone who's in 10th grade now. And so you're looking at 10 years worth of schooling. I didn't include anything from kindergarten or preschool, just hypothetically. And you can see for this student, there was a Woodcock-Johnson reading comprehension test done in 1st grade. It was repeated in 4th grade. Maybe this is a fairly typical scenario where you have a 3-year reevaluation done once every 3 years. So we see the Woodcock-Johnson reading comp test done in 1st, 4th, and 7th grade. If you're getting an evaluation that's in 10th grade, you might want to re-administer that Woodcock-Johnson reading test to see how have things changed since 7th grade. And also you'll be able to compare to 1st grade. In the really big picture, how have things come along in reading comprehension over 10 years? It doesn't mean that you wouldn't also do some other testing. Your evaluator might say, well, there's another instrument that I'd like to use that looks at reading comprehension, and obviously that's fine, and you want to defer to the expertise of evaluators like that. But you don't have to choose between them. You know, you could do both things. You could do a new kind of reading comprehension measure like the test of reading comprehension, and you could also do a measure like the Woodcock-Johnson so that you have an apples-to-apples comparison, and you can learn from both of those things. In the second row, you have another scenario where this girl has been tested in math, but never with the same instrument. So in 1st grade it was the Wyatt math. In 4th grade it was the Woodcock-Johnson math subtest. And in 6th grade it was the key math. Well, we can get a general idea where she's functioning in math in these different years, but we don't have apples to apples where we can say she had a score of 81 in 4th grade and it went down to a 76 in 6th grade. When you can compare those numbers, that gives you some powerful information to say, oh, good, she's making progress, that's good. Or she's not, we need to change something. The last row is just another example. You might have, you're looking at reading issues, and maybe you're looking at certain kinds of reading issues like fluency, like how fast and accurately can she read. And so there was a test given in 2nd grade to actually look at fluency, but then maybe for several years perhaps we haven't focused enough on fluency. We've looked at reading more generally, and in a 10th grade review of those skills, you might want to go back and pick up on a test that was first done a long time ago. And that is valid information too, to look at how a skill has developed over a long period of time. In the end, all this stuff is headed in the same direction, which is clarify the needs of the student, clarify your goals, clarify what information you're going to be bringing to the team, clarify what you're going to be requesting to keep the focus on the student, eliminate the static, get clarity, and make progress in resolving your conflict. When you get an independent evaluation done, you're going to want to share the results of the evaluation with the team. Using all of your background information from your binders, and now the new answers you have obtained in your independent evaluation, you're going to be prepared to offer specific proposals for the improvement of the student's programming, whether it's an IEP or a 504 plan or whatever. And we know that there are specific elements in an IEP, for example. One of them is, in the beginning you describe what are the present levels of performance for the student, basically where do things stand right now. You can talk about the historical perspective, and then you move forward in time to talk about the services that are needed. You will be in a pretty good position, I think, in a lot of cases when you arrive at this point to show up as a well-informed, organized, clear parent with some specific well-founded suggestions. I think it's interesting that when you in the due process procedures, which we're not talking about today because they're later and they come if all these kinds of things don't work, but when parents write a due process request, the law asks for parents to say, after they've identified what all the issues are, they ask the parents to describe their proposed solution to the problems to the extent known. It's not required that parents have a solution or put a solution out there, but it is something that's desirable in the legal scheme of things in special education. So a lot of this that we're talking about is kind of along those lines. It's getting you as a parent to the place where you do show up with a proposal for a solution, and that's a very powerful thing. It's a proactive thing. It's a constructive thing, and it makes you a very strong team player. A note about emails. Just kind of, this slide is just kind of stuck in here because it struck me at this point when I was putting this thing together. Emails are very convenient and also very dangerous these days, and when you're communicating with the school or you're communicating with people who might evaluate your child, or you're communicating with anyone associated with your student's education, try to follow the same rules with emails, namely, keep things focused on the student, don't get distracted with a bunch of static, keep your emails relevant to what's going on. Your emails are going to last forever. Don't conduct battles through emails. That's never good. There's no reason to vent with emails and do all those things. Just only use emails for constructive purposes, and make sure that you would be okay with all of your emails being seen later. If all of your emails got plugged into your binders and you eventually shared your binders with whoever, you want to make sure that you would be okay with that. The golden rule about respectful advocacy. It's super important to try to be respectful when you're working with school professionals, even when you may have a difference of opinion. I'm not pretending that I always do this in my work when I'm working with other attorneys who represent schools, but I try to do it. And it's really important to try to keep it at the top of your list, because when you're focused on the student and when you're eliminating all the static, in the end, we're all trying to meet the needs of the student. We're all trying to see progress. We're all basically pulling in the same direction. And respectful advocacy can be firm advocacy it can be powerful advocacy when it's based on the facts and based on the real needs of the student. And it's the most effective kind of advocacy, I think. And I'm using the term advocacy broadly to include the kind of advocacy that you as a parent can do on your own in the kind of scenarios we've talked about today. I'm talking about without an attorney, and maybe you have assistance from Vermont Family Network, maybe you don't. But these things can be very powerful. The other thing I like about these things that we're talking about today is that on this golden rule slide, next to the last bullet, is try to resolve things early and without lawyers. If you do these things early on, you've definitely got a better chance to resolve your case and not need a lawyer. It doesn't, and I'm not trying to be naive and pretend that everything's just going to work out fine in every case if you follow these steps. That's clearly not the case. But there are going to be many cases that do get worked out this way. I know that's true. There will still be cases where other kinds of help will be needed and other steps like mediation or due process might be required. But even if you do need those steps later on, even if a case is one of the more difficult cases that's hard to work out, all the steps that you've taken today will be helpful in that process because your records are going to be clear, the issues that are at stake are going to be clear, and you will have done a lot of groundwork that makes that next process quicker, easier. And there are always other tools to use. So, as I said in the beginning, we haven't covered mediation, resolution sessions, or due process hearings. Those are all later on if these informal efforts do not work. And as I said just now, even if that happens later, you'll be better positioned to handle that. So, we've got a couple text questions. I'll read these because you all cannot see them. How can parents show up with specific suggestions when they lack educational expertise? My child's speech-language pathologist told me there wasn't much that could be done for poor comprehension and fluency levels. Well, parents can show up with specific suggestions. Yes, I hear that they lack educational expertise, but what they do have is the ability to pull the documents together and ask the questions. So if you pulled all your documents together and gave an evaluator the key records and asked the questions, what can we do for poor comprehension and what can we do for fluency levels for my child? If you focus on those questions, then you get the educational expertise from an independent evaluator, or by the way, it could be from an evaluator who works with the district. The district might tell you, we will evaluate those issues about poor comprehension and fluency, and we'll see what can be done. But for the moment, I was talking about if you go to an independent evaluator, that's where you get the expertise. So you as a parent can help to frame those issues, and then you get specific questions elsewhere. Also, this presentation will be posted on VFN's website and emailed to anyone who registered as an attendee, so that you can look at all this information. Yeah. Here's another question. My child is now a senior and I'm not going to waste my energy on a process that hasn't worked for all the years she has had what I consider to be a useless IEP. If your child is a senior, I'm just going to shoot right from the hip here. If your child is a senior and you feel that the IEP has been useless for a long time, you still, I work with a lot of kids who are seniors or in high school. Kids with disabilities in Vermont are eligible for services until they're 21. And if there is a need for ongoing services, there are several ways to look at getting those done. I wouldn't necessarily give up on the process simply because a child was a senior. The other question was, can we get a copy of this? And yes, because it's going to be posted, right, on the VFN site, right? Yeah. And the next question is, sometimes parents no longer have trust in school personnel and vice versa. When this relationship is broken, can you recommend ways a parent can repair this and move on without feeling they have caved to the school? That's a really, really good question. The broken trust thing, in any relationship, broken trust, whether it's a marriage, a school relationship, a friendship, whatever, broken trust is huge. And you've got to try to repair the trust. I think that one thing that's good is to talk about it. I think it's sometimes good to say at a meeting, you know what, I feel like our trust is broken. I'm just saying the truth. I don't like that it's broken. I'd like to try to repair it. But if I feel like trust is broken, then that is one time that I would go out and get independent evaluation information, and I would say to the school, no offense, but my trust is shaken or broken, and I'm going to get some independent evaluation information, and I'm going to bring it back, and then I'd like to have an honest discussion about it. And the other thing that you can do sometimes is you can say, let's take a little bit of time and talk about how the trust got broken. It was broken for me because my child was supposed to get these services in second grade and they never happened, or she only got half of them, and now she's in sixth grade, but I still remember that and I never got over it. Or the school might say, we don't have trust in you because you said that you were going to provide us with certain information and you never did, or we feel like no matter what we do, it's not good enough, or whatever. I think that saying the truth is always a powerful thing, and so when you try to repair trust, I think I would say treat it like any other close relationship. Treat it with the respect and care that you would use in any other close relationship that's meaningful to you, and try to fix the trust. That's a hard question, though. Here's the next one. Some schools rush students on IEPs out the door when academic credits are met, even though transition goals are not. Strategies to prevent this? That's a good question. I agree that there is pressure to have kids graduate, get them out the door. There's a next batch of kids coming along. Come on, keep everybody moving. However, very important to remember that credits are only one criteria for graduation. They are not the be-all and end-all. You must also, another element that gets considered in graduation is whether reasonable IEP goals have been accomplished. So you've got to look at this, and you might say, you know, even though the student has credits, that student might still be eligible to age 21, or maybe just for 1 more year or 2 more years or whatever it is. Do not think of credits as the only issue to decide when graduation is the issue. Then someone said, great information, thank you. Okay, that's like awesome. We got a little more time. Here's another one. Do we? We got 5 minutes or something? Okay. Someone said, as a caseworker, this helps me to work with parents and get them more organized. Great, I love that. Next one is, can a school mandate a student cannot attend school until a medical plan is in place, referencing that it is a safety issue? Student's been out of school for over a month after an issue with a para-educator. We've gone through a bunch of stuff to get to where we are now. I'm repeating all the details. Let's see. This thing about a school mandating that a student not attend school, this looks like, I'm assuming this student is either on an IEP or a 504 plan because there's some kind of a disability here. So this is an IEP or a 504 plan. No, these are team decisions, right? There's no school mandate about this. These are team decisions about whether the student can attend school or not. If the school is worried about the student being safe at school, then the school might have legitimate concerns about keeping the student safe at school, and we might need to have a plan for that. If the school has a legitimate concern about a safety issue, I would want to engage the school in the specific, realistic, necessary elements of that plan. Unless it's just, you know, off the wall for the school to be requiring that, but I doubt that. They probably have some concerns, and I would want to be actively engaged in the development of that plan. Please remind the listeners that VFN has a helpline, and folks can call to speak to family consultants here if they have concerns. So that is a reminder from Martha Frank here at VFN. Anybody who has concerns about any of this stuff, because we are going to run out of time here, but just contact VFN, talk to a family consultant. Some of the questions that are getting posted now have a high level of detail and are specific to a particular child. Those are the ones that are good to call VFN, speak to a family consultant about your particular issues, and get some help with that. Let me see if there are one or two, because we're going to wrap up at 11, right? All right, so we'll take a few more of these questions. What's your recommendation when a school has decreased services because they say they can't document a need for them? My daughter has, I'm not going to describe the specifics, but my daughter has a disability, and she's had services since she was young. Is it a Cadillac service if it supports understanding, but it's not essential for basic learning? Two-part thing. Back in the first part of the question, when the school has decreased services because they say they can't document a need for them, first remember that the school alone cannot decrease services without the agreement of the team, and the parents are members of the team. So when there's a discussion coming along, And if someone at the school is saying, you know what, we can't document the need for these services anymore, we think we're going to reduce them, you as a parent would want to say, hold on, I'm not in agreement with that, and I'm not going to agree to an IEP that does that. And if the school cannot document the need for those services, then you are going to need to try to document the need for those services using everything we talked about today. So you would review your records, you would gather up the key records, you would go to an expert in the issues related to your daughter, and you would find out whether the need for those services can in fact be documented. And if they could be, you would then bring those evaluation results back to the school and say, with all due respect, I think the need for these can be documented, and I think my daughter still needs these services, and I don't want them reduced. If they are services that are necessary for your daughter to receive an appropriate education and make progress and meet certain skills, then they're appropriate services and they should be provided. In my mind, that is not a Cadillac. So that is a clear case where you would advocate for those services to continue. You say, what if it supports understanding, but it's not essential for basic learning? Well, understanding all the things that are essential for students to learn before they graduate and leave school and they go out into the world, understanding is a big deal. Understanding is key to a lot of what we're talking about. I would say no, by no means does understanding constitute Cadillac. So I would advocate for those things. Just shooting from the hip, based on this text I'm looking at, I would advocate for those things to continue. Another question, can a school force a child on a 504 plan to be a half-day student due to a new mental health diagnosis? Well, this is like the other question where it said, can the school force something? The school can't force this. The school might say that for some reason this child should be a half day because of whatever the diagnosis is. But the question is, under 504, what is necessary for this student to receive an appropriate education that's as adequate as that provided to students without disabilities? So most of the students without disabilities are getting a full day of school and not a half day of school. So if there is something that's preventing a student from attending a full day of school, my immediate reaction would be, how are we going to still provide this student with all the same curriculum, the same extracurricular activities, the same basic education that other students are getting? Is it going to be a full day in school with supportive services so that the student can be in school all day? And if so, what are those supportive services that are going to be necessary? If for some reason the student is only able to be in school for half a day, and if everyone agrees on that point, well, fine. What are we doing for the other half of the day? Are we going to do services at home? And I'm not talking about you homeschooling or being a homeschooling parent. I'm talking about, is the school district going to provide services at home for that other half day? Essentially, big picture, how are we going to provide this student with an appropriate education given the diagnoses? But no, school can't just force a half day. Here's another one. Placement is often an issue for parents. Schools sometimes say they can manage a child in the school, but continue to call the parent to pick the child up, rather than placing them in a more appropriate therapeutic setting. How can a parent effectively advocate for an appropriate alternative educational setting for their child? That's a real good question. The cases that involve other settings outside of the school districts, sometimes those things tend to come to lawyers more because they wind up involving a lot of money. The therapeutic schools all seem to cost a lot of money, so Vermont has tight budgets, school districts have tight budgets, and so if you start to look at an expensive school, that kind of raises the stakes, and the issues around conflict resolution can be cranked up a little bit. But again, shooting from the hip, when I hear about a school that's calling the parent to pick up the child, that's the same as saying, "Hi, can you pick up your child? We're unable to meet your child's needs. We are unable to provide an appropriate education for your child, so can you please take over?" And while it may be that the school district, there's several possibilities there. One is that this student just needs a different setting. Maybe this student needs a therapeutic setting in another school. And if so, then we need to determine from the history in the binder, from evaluation information, from everything we're looking at in the current situation, does this student need another setting? If so, why? What are the specific reasons? And you identify those reasons, you share them with the team. If that's what the student requires, then that's what the law requires. So a parent, at the very minimum, when a school calls to have a parent pick up a child, it's a huge red flag saying the school district is not able to meet that student's needs. It doesn't mean they might not possibly be able to if they put in a lot more services so that they didn't need to call the parent. But one thing that I do know, looking at your particular situation here, when a student is placed in a therapeutic setting, those settings don't call the parent to come pick up the child. They are dealing with the issue in a therapeutic setting in real time, and whatever is triggering that phone call to come pick up the child, whether it's a behavioral issue or the student is just melting down or shutting down or whatever it is, that's the whole reason for therapeutic intervention to be happening at that moment in real time. And if the school is saying, we're just checking out on this right here, that's an opportunity lost to do the therapeutic input right there. So how can the parent advocate for that? You've got to keep these steps in mind that we've talked about today, but also realistically, if you're looking at something that's going to cost a lot of money like that, you might need legal help. And I'm not advertising on it. Whoever you might call, you might need legal help for that, just because there's a lot of money at stake. Here's the last one we'll do. Do you think if Vermont could get a due process to move all the way to a hearing, and if the parent prevail, we could improve our rules, for example, around adverse effect? So that question refers to Vermont has these sort of funky rules about the hoops you have to jump through to become eligible for an IEP, and Vermont Vermont is the only state in the country that has these kind of strange set of rules. And the strange thing about them is that when looking at whether you're going to be eligible for services, regardless of what kind of a disability you have, you've got to prove that there's an adverse effect on a basic skill area, which Vermont defines as things like reading, writing, and math. So unless you can show that you're pretty far behind in one of those things, you're not going to get services. Even if you're a child with an emotional disability, or a child with autism, or a child with a health impairment, or whatever it is, we've got a pretty prehistoric set of rules around that. People all around the country look at Vermont's rules and say, what the heck is that? The good news about this is that the there are some recent hopeful signals that the powers that be in Vermont might be willing to have a look at these issues, and there might be some progress that's being made, and we can talk about that a little further perhaps. So I'll sign off, and I want to say thank you for joining us for today's webinar. This webinar will be archived on Vermont Family Network's website, along with many other previously recorded webinars. Be sure to visit VFN's website at www.vermontfamilynetwork.org for a complete list of upcoming webinars, workshops, and support groups. Have a good day. Thanks a lot.